Assistant Attorney General Bob Litt is in Washington. He's also a former general counsel for the U.S. Director of National Intelligence. Good to see you, sir.
Thank you, Vlad and Marie. Nice to see you.
All right, so Attorney General Barr quoted the special counsel's report saying, while this report does not conclude that the president committed a crime, it also does not exonerate him. This was a nearly 2-year investigation by the special counsel, summarized in less than 2 days by the AG. What does that suggest to you about the president's level of guilt or responsibility?
Well, of course, it's very hard to tell without seeing the underlying report. We don't even know how long Mueller's report is, let alone what it concluded. But it's obvious that Mueller found some evidence that could be consistent with an obstruction of justice. But for whatever reason, he did not draw a conclusion on that fact. I think it's interesting to notice also that on the issue of collusion with the Russians, I think a lot of the media reporting is overreading the Barr's letter, because Mueller did not find that there was no evidence of collusion, as some people are reporting. He did not find that there was no collusion. What Mueller did was say he couldn't find that there was collusion. And in fact, the language of Mueller's report, which Barr quotes, which says it did not establish that there was collusion, is strikingly similar to what Barr found with respect to obstruction of justice, which is that it did not establish an obstruction of justice offense. So I think we can perhaps speculate that there may, in fact, be evidence of collusion, just not enough to warrant a criminal charge.
You know, a lot of people were sort of caught off guard by how quickly AG Barr was able to put together this summary of the report. Is 2 days enough time to read the report, come to a conclusion, and deliver this sort of highlight reel, if you will?
Well, it's important to note that Barr said in his letter that Mueller and his team have been consulting on an ongoing basis with people in the Department of Justice, including presumably the Attorney General and the Deputy Attorney General. So this probably did not come as a complete surprise to them. They probably had some knowledge of this beforehand. That said, again, of course, it matters whether Mueller's report is 20 pages long or 2,000 pages long in terms of the ability to summarize it in a short period of time. More important is whether the summary is, in fact, a fair reflection of what Mueller's underlying findings and conclusions are, and that we won't know until we see the document itself.
Bob, I want to read you a tweet from John Dean, who I know you're very familiar with, the former White House counsel during the Nixon administration, who ultimately went before the Senate to talk about what was happening in that administration during the Watergate hearings. He tweeted this: having reread William Barr's June 2018 memo critiquing Mueller's obstruction investigation and now his summary of Mueller's report, it is clear that Richard Nixon would not have been forced to resign his office if Barr had been Attorney General. Barr wants a POTUS above the law. So we talked a lot, you and I and Anne-Marie, about that 2018 memo. What's your take on what John Dean is suggesting here?
Well, I'm just going to have to go back to not knowing what it is that Mueller actually found in this regard. But there was, for example, evidence of, in Nixon's case, of actual payment of money, of hush money. And Barr's memo, as I recall, said that a president could be guilty of obstruction of justice if he took steps for the purpose of influencing people's testimony directly. And that was certainly the case in Nixon's case. So it's not totally clear that how this tracks against the Watergate matter, but it is clear that Barr had a very narrow view of what could constitute obstruction of justice by a president.
So let's talk a little bit about that. Let's talk about what we do know. We do know that the president admitted that he had the Russia investigation on his mind when he fired FBI Director James Comey. We know that he repeatedly and publicly called the Mueller investigation a witch hunt, said it was illegal. In fact, he just said it was illegal. Even though it's sort of falling in his favor, he's still calling it illegal. And we know that he refused to sit down with the special counsel. Now, he answered questions in writing, but he wouldn't sit down with an investigator. Couldn't that be considered obstruction of justice in some way? How is it not?
Well, again, according to Barr's theory, the only way a president cannot obstruct justice by taking steps within his constitutional power, and that would include firing the director of the FBI. Barr's view is that the only thing that could constitute obstruction of justice is direct attempts to influence testimony. And it's very hard to establish, for example, that public statements that a investigation is a witch hunt are intended to directly affect testimony. That said, there are other people who believe there's a broader view of obstruction of justice that includes attempts to influence the investigation, but it's the Attorney General who gets to make the call here because it's his Department of Justice.
You know, what the White House is now saying, Bob, as Anne-Marie pointed out, is that the president can't have obstructed anything if there was no crime, if there was no collusion, right? But reminder, you may not be all that familiar with this case, but a lot of people who follow sort of the happenings of celebrities will remember that Martha Stewart went to jail for obstructing justice, and it was, even though it was very similar in the sense that there was no crime, but she was obstructing the investigation. So can you still obstruct justice if you haven't proven there was collusion?
Absolutely. Barr's letter is fairly carefully worded. It's true that evidence of motive is a strong factor in support of obstruction of justice. That is to say, if you can establish that somebody has committed a crime and they're trying to prevent that from being disclosed, that's evidence in support of obstruction of justice. But the fact that there's no crime doesn't mean that there's no obstruction of justice. The president may have wanted to protect other people. He may have wanted to avoid disclosure of other issues. So it's not necessary that there be an underlying crime.
Really fascinating stuff. Bob, always great to have you, sir. Thank you very much.
Thank you for having me.
So earlier, one of